Good afternoon. Welcome to Transforming Legal Practice, Lawyers Increasing Access to Justice. We begin by acknowledging that this session is broadcast from the traditional and unceded territories of the Coast Salish peoples, including the territories of the Musqueam, Tsleil-Waututh, and Squamish nations. Those joining us from throughout the province similarly are situated on traditional territories of Indigenous peoples. And no matter where we are, we acknowledge and appreciate the opportunity to gather on their lands. In doing so, we are mindful of the impact of Canadian laws and policies have had on Indigenous people in our province, and we look for opportunities to learn about that impact and in turn reform those laws and policies. My name is Carrie Simmons. I use the pronouns she and her. I'm the Executive Director of the Canadian Bar Association BC branch, and I'm pleased to be your host and moderator for this session. Let me share a little bit about how you can participate in today's event, and then I'll move on to why we are here and introduce you to our program and our keynote speaker. The platform we are using is Zoom Webinar, and as such, as a default, your microphone and video have been turned off in order to improve the audio and video quality. At the bottom of your screen, you'll see a chat section. If you experience any technical issues or need help from a technical perspective, please put that in the chat. But if you'd like to pose a question to any of our speakers, use the Q&A section. That's also at the bottom. Just type in your question or comment there. And if for some reason you want to pose your question anonymously, you can also do that. It's just when you submit your question, you'll check the box that says send anonymously. It's right there at the bottom. At the end of the presentation and the discussion with our panelists, I will pose your questions to all of our speakers as time allows. And my last point on participation is that you can tweet and comment on social media during this event. Please use the hashtag A2JWeekBC. So, why are we here? Well, the Honorable David Eby proclaimed this week Access to Justice Week in British Columbia, giving all of us an opportunity to highlight the progress we have made to increase access to justice for all British Columbians. And there's many events and activities happening this week to do just that. When I say give us an opportunity, I mean lawyers, law students, educators, judges, community advocates. I mean institutions like the Law Society and law schools, associations like the CBA BC branch, and key service providers like our courts and tribunals, Legal Aid BC, courthouse libraries. There's lots of progress being made. And every small improvement, which may seem insignificant in isolation, can compound to create dramatic results. We need to keep going, and we need to get better at destroying the barriers that make progress difficult. We need to keep learning more and challenging established ways. So this event today is made possible by the Law Foundation, the Law Society, the Continuing Legal Education Society, Access to Justice BC, and the CBA BC branch. Over 155 people are watching this live, and I know even more will be watching the recording in the weeks to come. We're here to talk about the transformation of legal practice. Our focus is on lawyers who approach their work in a different way from traditional private practice. The approach is also different from what they learned in law school. I'm sure they're going to inspire you to make some incremental changes in your own practice. To launch our learning today, we are pleased to introduce you to Rebecca Sandifer, professor at Arizona State University and a faculty fellow at the American Bar Foundation, where she founded and leads the Access to Justice Research Initiative. I'm sure you've read Professor Sandifer's detailed biography when you registered for that event, so I'm not going to repeat it now. But you may be wondering, if this session is about lawyers transforming their practice, why is a sociologist from Arizona speaking to us? Well, that's because Professor Sandifer's research and reports tell a story of what people need to solve their legal problems. Not who they need, but what they need and how. That user-first understanding is something that our panelists have embraced in their practices. And for some people, this is a different way of thinking. So let's start by listening to Professor Rebecca Sandifer, and don't forget to put your questions in the Q&A.
Thank you very much. It's a privilege and a pleasure to be with you today, and I regret, as I always do at events like this, not to be able to see you in person, but I look forward to that happy day. I want to talk today a little bit about what research shows us about how we can better connect, or actually how you can better connect with ordinary people who have justice problems. So I want to start by reminding us of something that I know everyone who's in this meeting knows, which is that there are an enormous number of people in your country and my country who have civil justice problems for which they get no assistance. And so these are just some highlights from research that's been done on British Columbia, where a few years ago, one of your law societies worked together with a very reputable survey firm to point out that 83% of Canadians with incomes less than $50,000 a year were experiencing at least one civil justice problem. But the most common kinds involved consumer issues, housing and land, money and debt. This is very much like what you would see in other societies, but it also means that many, many people are experiencing issues that are falling in core areas of life that affect their ability to take care of their families, to make a living, and to have a place to live. And what's happening in British Columbia is true of the country generally. So a few years ago, the World Justice Project, I think for Canada, this represents 2018, did surveys of over 100 countries asking people about their experience with civil justice problems. And what you see there is if you ask people, tell me about the previous 2 years of your life, over half of Canadian adults had at least one civil justice problem. These problems are impactful. Another thing we know from the World Justice Study projects is that almost half of the problems that Canadians experienced led to some kind of hardship. So 15% of those problems, people said, caused them to have additional health problems. 13% caused them to lose their job or to lose their income or to lose their home. 10% nearly led to damage to their relationships, and about 5% led people to self-report that this problem affected my life by causing me to use substances in ways that I wasn't comfortable with. So these are very, very impactful issues, as you know from your own practice, and most people don't get any help for them. So in this World Justice Project survey of Canadian adults, just about a third of people were able to get help from anybody, right? But that also includes your friends and families and physicians and community leaders and religious leaders and so on. And so less than 20% of the justice problems that Canadians reported in this survey got any kind of assistance from a legal expert, a legal aid lawyer, a private practice lawyer, someone like that. So if you're thinking about the way ordinary people experience civil justice problems, if you're sitting in a court or in your law office, the people who you're seeing are that 20%. They're the people who are at the top of the iceberg above the surface, but in fact, most people don't make it to court. Their justice issues don't become court cases. They don't make it to an attorney's. And so if you're thinking about this as a justice gap, that gap is very big. If you're thinking about this as a latent market for legal services, it's a very large latent market for legal services. Now, why is it that so little of that activity makes it up to the surface, to the tip of the iceberg? Well, one of the most important reasons, when I started this research, I thought what many of you may think, which is that the most important thing is that legal services are really expensive, and that's why people don't buy them. And certainly cost plays a role. But actually, prior to even thinking about cost, one of the most important factors that shapes how people handle their problems is how they think about them. And we know that people often don't recognize that their justice problems are legal. And one way to find this out is to do, they're called justiciable problem surveys. So instead of asking somebody, hey, tell me, do you have a legal problem? You say, are you 3 months or more behind on your rent? So therefore you're at risk of eviction, for example. Or does your employer owe you overtime that he's not paying? So that's wage theft, right? So you describe situations that are concrete, that people can recognize, that have legal elements to them. And then you say, okay, you've told me you have one of these situations. Your employer's not paying you overtime. You're 3 months behind on your mortgage. What kind of a situation is that? Is it a legal problem? Is it a personal problem? Is it a bureaucratic problem? Is it bad luck? So on. And what you see, this is data for the United States, but you see very similar patterns around the world. The most common way that Americans describe their civil justice problems is as either bad luck or as part of God's plan for them. So these are things that they understand as just happening to them, either because these kinds of things just happen to all of us, or they're happening to you because they're supposed to. This is part of what is supposed to be your life. You're probably not going to file a lawsuit about bad luck or about what you believe a divine authority has given into your life. There's another chunk of problems that people describe in ways that suggest they think they're probably not appropriate for third-party intervention. So maybe somebody should do something about this problem, but that somebody is us. So this is my problem, it's my family's problem, it's my community's problem, excuse me. And it's for less than 15% of problems that Americans, and this is true in many other jurisdictions, think of those justice problems as having legal aspects. And so that's an important gap to leap across. The fact that people don't see their justice problems as legal and therefore don't see lawyers and courts and other kinds of legal providers as important places to go when you have those kinds of problems. Another thing we know from research, mine and many other people's, is that when people are in trouble, and this will make sense to you if you think about your own life, you seek help from trusted sources. In this survey that I did in a sort of middle-sized city in the Midwestern part of the United States, if you say, okay, you told me you had a problem of this type, a wage issue, a housing issue, an employment issue, did you go to anybody for help? And so about 16% of problems people did nothing about. The most common thing people do, and again, this is true in many jurisdictions, is they try to solve the problem on their own or handle it on their own. And then when they reach out for help, the first place they go is to family and friends. And then they might go to a community organization or an attorney or their elected official. But you sort of start within your network and then you move out. And this is very, very common. Once people decide that they want to contract with lawyers to use specifically legal services, they still go through those personal networks. And this may be surprising given how much all of us use the internet to do things, but it's still the case as of last year, 2019, that the most common way in which people found a specific lawyer was by the recommendation of someone who they knew. That the red bar in this graph is internet search, and it certainly is increasing over time, but it's still not the predominant way in which people pick a specific lawyer once they decide that they need one. They still go through networks that they're connected to and that they trust. Another important thing to recognize about people confronting justice problems is that they often feel fairly confident that they understand the situation and what is and isn't possible. And you can see this in survey data. So if you ask people who report a justiciable event and you say, okay, you told me you didn't go to anyone for help with that event. You didn't go to a family member, you didn't go to an elected official, you didn't go to an attorney. Why didn't you go look for help? And what you see is that yes, and this is true in Canadian research that, for example, Ab Curry, who may be known to you, did for the government for many years. Cost plays a role, but it's never the number one reason that people don't seek help. It's never the number one reason that they don't seek out attorneys. They're much more likely to say, I didn't seek help for this problem because it wouldn't make any difference, or I don't need any help. So I understand this, I understand what's possible, and I'm doing what makes sense for me. And of course, sometimes they're absolutely right. What we worry about are the people who are disastrously wrong, who don't understand that if their employer is stealing their wages, they actually have recourse, for example, or who don't understand that their landlord has to make sure that their apartment has heat in the winter, right? So there's a gap between understanding and people's actual rights and sort of leaping. That's another gap you have to bridge when you're thinking about connecting with people who need what you have to offer. Another thing that we know from both studying people trying to solve problems, but also from market research about what clients want from lawyers specifically, people want transparency and they want clarity. So there's a law practice management software company called Clio that some of you may be familiar with, and every year they do a trends report. It's fascinating. It's based on both surveys of consumers and then surveys of the behavior and activities of their clients. And so if you survey consumers and you ask them what's important in choosing a legal services provider, so these are pretty savvy consumers because they've actually used legal services. They want to know how much it costs. They want to know what the steps are. They want people to respond to them in a timely way, and they want people to answer their questions. And this sounds all very basic, but certainly American lawyers are very bad at doing these things. But this is what consumers want. They want transparency, clarity, next steps, and timely responses. So this puts you in a situation as somebody offering help to people who need help, where you have some challenges that are also opportunities. So people prefer to seek help through routes that they already know. They don't connect their justice problems to law or to legal solutions typically. And they work best with information that's targeted to their situation. And this turns out to be even more important when they feel like things are uncertain. So what can you do? Well, you can sort of distill the principles into four, the 4 T's. So you design help, interventions, services that are targeted, that are specific to the problem that the person faces, rather than a bunch of general information about, say, landlord-tenant law, right? The question is, what do I do when he won't give back my security deposit, for example? Timeliness is really important. So the help should arrive at a moment when the person realizes the help would be useful. And there are a range of ways to make sure that that is part of delivery. Trustworthiness is obviously very important. So it should come through some conduit that this person believes means well by them. And then finally, transparency is obviously very important to people. So not just transparency about costs, they certainly want to know that, but about what's going to happen. What are my decision points? What are the steps here? So I just want to share with you some examples of techniques that different providers have used to respond to the 4 T's. So one is to be problem focused and timely. These are beer coasters, and they come from Montana Legal Aid. Montana Legal Aid had them all printed up, and they sent them around the state and distributed them in bars. And if you go into a bar in Montana, you may plop your beer down or whatever your beverage of choice is, and you'll see a question like this. So if my ex-spouse didn't pay on our credit card, do I have to pay? So very concrete question that could happen to any of us, perhaps. And you flip that beer coaster over and it tells you, yeah, you do actually have to pay, but here's a place you can go to get some more information about what you can do. And they have a series of these about landlord-tenant law, about your rights and responsibilities if you have a disability that you're taking medication for, and so on. So this is a way of targeting information to problems as people understand them in the places where the people are already going. The city of New York has a set of billboards and leaflets that basically give legal advice about very narrow things. And in New York, if you give it as a public notice, it's not legal advice, it's legal information. So this one says, if your landlord says, if you want to rent this apartment for me, I need 3 months rent for security deposit. This says, okay, here's specifically what you say to your landlord. You say, no, I'm sorry. The law actually says it can only be 1 month's rent, right? So the information is focused around a concrete problem that people actually face, and it's very focused on that one problem. There's another wonderful resource in New York City that's a bit more sophisticated, which is a program called Just Fix. And there's a range of activities that this organization does. But the way they started was by recognizing that one of the big problems that people living in low-income housing or lower rent housing in New York City have is getting repairs, heat, mold, rats, and so on. And so this program is something you can download to your phone or use on the web from a computer, and it takes you through a guided interview that asks you what the problems are in your apartment that you need your landlord to fix. It asks you the address. It goes to a city database and looks up who owns that property. and that person's official contact address. And it asks you to take pictures of whatever conditions you're talking about with your cell phone. So if it's rats, you take pictures of the rats. If it's mold, you take pictures of the mold. You press complete submit, and it writes a beautiful letter that quotes city housing code, and it sends it as certified mail to your landlord, demanding kindly and politely that your landlord make these repairs. So they're pretty successful at getting repairs, but then this is also the first step you need to take if you want to file a lawsuit for housing code violations, or you want to make a complaint to the city, right? So you're sort of laying the groundwork for other kinds of actions by doing this. The other thing that seems to be very effective is to embed help in the places where people already go. So both in Canada and the United States, there are programs where you send social workers and attorneys into the places where, for example, homeless people are going for issues of sanitation, safety, and heat. And that would be libraries. So that's where that population that you want to serve already is. And so you reach them there and connect them with services there. Medical legal partnerships are burgeoning around the world. And the idea there is that many people who have health problems, there are legal problems that contribute to those health problems. So going back to the example of housing conditions, one of the biggest aggravators of asthma attacks in children is the feces of cockroaches. Well, that's a pest infestation that's usually managed by housing codes. And so when someone takes their child to the doctor and says, my child keeps having these asthma attacks, part of the treatment of the asthma is the legal remedy of making the landlord fix the apartment, right? So people are going for help with one kind of problem, and you embed the legal help there. In New York City, and I think they're going to expand a little bit further out in New York State, there are storefront information centers where people come in and drink coffee and eat cookies and chat about the day, but you can also bring in a letter you've gotten from a government agency or from a creditor and say, what does this mean? And they'll help you look up information. They'll connect you with constituent services. They'll refer you to legal aid and so on. So you sort of embed it in the neighborhood physical spaces where people are already moving around. Another really interesting development in the United States that may be happening in Canada, I don't know, but you can tell me about it, are something that we call a faith and justice alliance. So you recognize that when people are in trouble, they very often go to their faith communities, to their pastor, to their mosque. And so you train the frontline workers of those faith communities essentially to issue spot and make referrals. So if somebody goes in and says, Pastor, my husband is really frightening me. I'm afraid he's going to hurt me. In addition to praying with you and counseling you about how to handle that very human problem, your pastor would also say, I think maybe you should talk to a domestic violence advocate or a legal aid attorney and think about how you can make sure that you and your kids are safe, right? So you embed legal help where people are already going for help with different kinds of life problems. And then, of course, there is what they call in the UK Tesco law, what in the US we would call Walmart law, sort of kind of regulatory changes that might allow those services to be available in places, again, that people are physically visiting all the time. Transparency is also very important, and not just about cost, but about steps. So that, if I'm a person in trouble, I'm in a confusing and frightening sometimes situation, and I want to understand that situation and what my choices are. There are some really great examples of being transparent about process. So this is an example from some materials that were sent out by a legal aid society to help people understand debt claim lawsuit paperwork that they got. And if you send people these very simple pictures of this guy who understands that I fill out 3 copies of the form and I mail 2 and I keep 1 for now, that doubles the rate at which people file answers, which is the first step in responding to a debt claim in the US. And it halves the rate at which people default. So we have incredibly high rates of default in debt lawsuits, depending on the jurisdiction, 65 to 90%. So getting people into a position where they can participate in their own legal matters, being transparent about process can be very helpful there, and delivering it to them when they know they have the problem. And of course, you can also be transparent about price. And if you look at the internet-based legal services providers in the US, the UK, being transparent about prices is what they do. So, we will work on this problem for you and do these things for this amount. This is Co-op Legal Services, which is basically almost a grocery store, but they also do funeral services. They do a range of other kinds of services in the UK. And of course, you're probably familiar with Rocket Lawyer, where you know that for $40, you have access to a certain set of services. You can add on attorney services, and it's upfront, and you know what you're getting and what you may need to pay for in addition. So you can take these 4 principles, and I suspect think of many creative and effective ways to use them to meet people who need your help. The most sort of underneath being timely, targeted, trustworthy, and transparent, is thinking like the people who you want to connect with and going where those people already are, whether that's a physical place, a social place, or an internet place. And I really look forward to learning about the innovations and clever ideas that your colleagues there on this panel have developed. Thank you very much.
Thank you, Rebecca. As I was sitting here listening to you, I could recognize in the statistics that you were sharing, even though they were about the United States, similar statistics that we have here in Canada, particularly those through the National Self-Represented Litigants Project. And so I can definitely say that what you shared with us can't be dismissed just because it's the States. It's actually the same here, and all the learnings that you're sharing with us are equally applicable here. It's interesting to hear your comments and how you've put all it together with those 4 T's, the 4 T's of targeted, timely, trustworthy, and transparent. That's something that I'm sure we can all tuck in our heads, make a note of, and reflect on going forward. I'm now going to invite all of the attendees to use that Q&A feature at the bottom of your screen, and you can put in questions there that we can take to Professor Sandifer at the conclusion of this next section. So don't be shy. Put that in there, ask a question, make a comment, and that'll provide a further engaging discussion later on. For the benefit of our attendees, I'm going to start by giving them a brief introduction to all of you. For those who looked on the CLEBC's website when you registered, you would have read more lengthy bios. I'm going to share with you in this case why these people are here, and then during our conversation that we're going to have, let them share some of the more details of what they do and why. So I'm going to start off here by introducing Nicole Garten of Heritage Law. Nicole has been in practice for about 20 years in both family law and wills and estates. And I wanted Nicole to come join us today because I remember when I first started practice many, many years ago, like Nicole did, seeing that she was one of the first firms that did things differently from what I had been taught in law school. And Nicole and Heritage Law had a virtual practice and started experimenting early on with using online portals and ways that clients could find her and her services in a way that they didn't actually have to go to a physical office necessarily. So I know Nicole's going to share with us some of her tools and tricks that she uses and her philosophy in doing that work, with a special focus on the wills and estates practice. Because sometimes when we think about access to justice, we think of maybe family or landlord-tenant disputes and things like that. But some of the principles that we're talking about apply to all areas of law. So thanks, Nicole, for being here. Next up, Sonali Sharma of Athena Law. Sonali is well known to many people on this call because she has been using unbundled models of service for quite some time, and following, and it probably is a great example of that transparent approach to working with clients. So Sonali is going to share with us that service model with a focus of unbundling services, and she too has a family law and wills and estates practice. Joel Payne is from Payne Litigation, and he is a commercial civil litigation trial and appeals counsel, and his practice is 100% cloud-based. There is no paper in his office, not less paper, but no paper. And so that is, again, a difference in how his service delivery model is set up. So it'll be interesting to hear how Joel uses technology to make sure that that's how his system works. And he's going to share with us how that works for his clients and what they tell him about that as well. Laurel Dietz is a lawyer from Victoria, and she has a family law practice. And Laurel is going to share with us not only how she does service delivery with unbundled services, similarly to what Nicole and Sonali do, but also talk a little bit about legal coaching and what that looks like and why she's moved into that kind of practice. And then last but not least is Chilwin Chang. Chilwin is the principal of Ascendian Law. He has a commercial and regulatory litigation practice. And what's interesting about Chilwin's path to today is that he took a break from law at one point and started to look at what could be done differently. In completing his MBA, he started to figure out what's services or approaches could be taken that might intentionally disrupt the legal service space. And through that and after that process, he has maybe returned to the practice of law and is now running his practice in a way that definitely uses principles that he learned through his MBA studies and his research and strategies around that change how he delivers legal services. So those are really brief introductions about everybody, but we're going to now get into a bit of a conversation. I have questions for each of these people. We're going to do a bit of a round table, then we're going to have a bit of a free-for-all. But throughout, for those of you watching, please put your questions in the chat, or not in the chat, in the Q&A, and we'll get to them later on. So, are you ready to go, guys? Thumbs up, that's good. So, I'm going to actually start with Nicole. So Nicole, could you share with us a couple of things that you purposefully do differently in your law practice?
I would love to, but first, can I do a shout out to some of the attendees? Because I checked out who was watching this, and it's some of the absolute leaders in the profession for access to justice. And I just wanted to say, like, we've got Carrie Boyle, who runs the BC Family Justice Innovation Lab, and we've got Jamie McLaren, who runs Access Pro Bono. And I saw Darren Thompson on there, who's done like amazing things in terms of the online dispute resolution stuff. And he's got his podcast Law Actually, where he's got leaders in A2J. And of course, Chief Justice Bowman has been a leader in this and blogs and stuff. So I just wanted to say hi to all these leaders that are participating. So yeah, maybe I'll preface that. The other thing I just want to say, thank you to Professor Sandifer. So what I found really interesting about her remarks is that people often don't even know they have a legal issue. And when I was at Osgood, I did an LLM in alternative dispute resolution, and there's a seminal article by Festinger, and it's called The Emergence and Transformation of Disputes, but it's called Naming, Blaming, and Claiming. And a lot of particularly disenfranchised people have a unperceived injurious experience that they then become cognizant of, but they don't get to the claiming and blaming stage. So they don't even know they have a legal issue. And some of the most sort of, disenfranchised people of our society don't even know. And so that's part of our challenge. But I think in the context of us providing techniques, like Jerry McHale, who a lot of you know is a professor at UVic, and his on this area, and his thing was, for access to justice, we've got three choices. We can stop case volumes, which is, prevention. So, people staying out of the justice system, not getting arrested, not having problems to start with. And that's the, whole societal thing in terms of us and, empowering our poorest, most marginalized people. You can put more money into the system, which I know we're all advocating more money, certainly for legal aid. And then the other thing is we can do efficiencies, right? So I think we're talking about the efficiencies that we provide that allow us to provide more cost-effective legal services. And you're right, heritage law back in 2005 when I started it, I think if we weren't the first, we were certainly one of the first virtual paperless practices. And so I do a lot of the stuff that people do now, which is probably more standard. So I do unbundled just like Sonali services. And by the way, Carrie Boyle is a huge leader in unbundled legal services. I do transparent pricing. So I have actually, it's kind of blasphemy in law, but I actually have like flat fee pricing right on my website. I do online payment. And actually, I think Jeremy Hessing is on here too, who actually helped me I think he's one of the participants or attendees, and he helped me set up the online payment. Certainly we're cloud-based and transparent and paperless. And that allows not just in terms of efficiencies, but you have greater access to talented staffs. And I think it increases quality. Like it's very difficult for us to miss a conflict, for example, being entirely paperless. We really can't miss a name kind of thing. And so that's the idea. But the one thing I think that's kind of unique now is back then, I was saying this to Carrie, we had a completely automated wills option, which actually kind of failed because I think it was too early. So I believe it was like for $200, you could log into this completely online system and you had to fill out a questionnaire. And if you had a disabled child or a blended family, or if you were First Nations or a US citizen, like there were certain things where they kind of picked you out of the system. But if you didn't fit those sort of more complicated criteria, you could go through and do a full will, a full power of attorney, and a full representation agreement for $200. And so the idea was geographically, economically, people with mobility issues, it could serve people and allow people to get these basic documents that half of Canadians don't have. But the interesting thing is it was a huge investment. Certainly it wasn't a money-making thing. And I was nervous about risk. And, there was strangely very little uptake. And we just made a business decision that, given the risk and the expense of running it, if so few people were using it. And so we actually shut it down. So that was, I think it was about 10 to 15 years ago. And so I wonder if there would be more of an appetite for it now, if the general public's has an appetite for technology. So that's enough about me. I'll stop talking.
Thanks, Nicole. Some of the things that you mentioned that you continue today, like the online payments or the unbundled services, why did you decide to try some of those things? What were you seeing that made you decide you were going to do that?
Well, I think all of us that practice family law, there's enormous unmet need. And, there's a ricochet of social, economic, criminal, health issues, children, for, middle income people that they go into this system, which is confusing, Byzantine, it's not meant for lay people. And, there's just a huge unserved population. And so the thing is that you have to be efficient to be able to serve these people in a cost-effective way. And they're terrified about fees. And so I think a lot of the ways to do it is to be highly efficient, to be automated, to do flat fee, to be transparent, just like Professor Sandifer said, because as we all know, it's a huge privilege and honor to practice law. We are extremely privileged to be able to do this. And we need to leverage that to be able to help. It's part of us is, none of us are here to make the big bucks. So we make a living, but we're also here to serve the public. And so it's just part of being able to serve the demographic. And I think all of us that practice family law, that's just part of our practice.
Thanks, Nicole. I'm going to move on to one of your co-panelists here and move to Sonali. Sonali, tell us a couple of things that you do differently in your practice.
Okay. Yeah. I so unbundling, as you said, is like a huge part of my practice. So some of the, I guess, if I was to break this down in sort of discrete sort of breakdown, I would say um, you know, the use of like online apps, for example, for scheduling, and then having an automated system like Nicole described, where you're not just doing your online payments, but you're also doing your intake through that. Because with unbundling, one of the big sort of components is the screening process is very key, because not every client is suitable. They may not have the mental, emotional, or physical capability to carry out sort of their end of the accountability or partnership that unbundling or limited scope retainer services require. So that's one of the things. And the other thing, so a huge part of my practice is collaborative family law. And so I just want to give a shout out to Woody Mostyn, who's also an attendee, and he's considered the grandfather of unbundling out in San Diego. So we just did a 2-day workshop on how to unbundle your collaborative practice. So one of the things about collaborative practice is, going back to what Professor Sanifer said about how people don't really understand the legal aspects. But then if you look at the World Justice Justice Study, which said, 49% of people who have legal issues, experience some kind of hardship, some kind of health issues, whether that's mental health or physical health, and then also negative, and then 13% experience negative economic impact. So, collaborative is about sort of multidiscipline, so working with other professionals. And so what I find is sometimes when you triage some of the financial pieces to, for example, a financial divorce coach or a neutral, or if somebody's having a really hard time dealing with their emotions in terms of closure with the ending of a relationship or a death of a family member, then somebody who's a mental health professional is better suited for that. And then what that does, or what I've seen, is that it helps to kind of uncover and make it easier to understand the legal aspect. And so the legal aspect almost becomes sanitized in this COVID era. And then it's easier to kind of get to that workable solution. And so, like when I think of the triple aim of access to justice, I use this in my practice where I'm constantly thinking of like, how do I improve the user experience? And one of the ways to improve the user experience to access to justice as a practitioner is being familiar with the resources that are out there. So using My Law BC to help clients, using the unbundling roster services, for example, the toolkit that's been created through the Access to Justice working unbundling group with Jane Morley and Carrie Boyle, who are here today. And, like sort of directing people to the the client consumer facing websites like the People Law School has put out there. So it's really working with other stakeholders that are committed to providing access to justice, and how we as practitioners having the responsibility or the accountability to understand that those resources are available and promoting those resources so that they're used. And so there we go.
As I'm listening to you, I'm wondering if you could share with us a little bit about what clients tell you they like about what you're doing, or even what their reaction is to the kinds of approaches that you take.
I think there's a huge trust piece, and the transparency piece is really key. I mean, Nicole hit on this fabulously. And I have to say, I also want to thank Nicole, because she's been like a huge inspiration for the type of practice that I have. And one of the things that clients often, the feedback I get is that they felt like they had control over their own matters. So it's, so being their own case manager, where having that ownership or feeling that sense of empowerment was really important, especially when you're dealing with family issues or issues dealing with death, that because closure is huge, right? So that was key. And then the other thing is the sort of fee transparency. I mean, that's huge. Coming up with a budget and working within the budget is it helps to alleviate a lot of the anxiety that I personally experience from the consumer or the client, wherein they feel sort of, what am I paying for?
Thanks. One of the great things about having this panel together is that you're going to start to hear some different ways that we approach our clients or approach our businesses, and but everybody's got a different take on that. So I'm going to go next to Joel. And Joel, just to start off, I know you do many things. Like I said, it's an entirely cloud-based system there, but why don't you share with us a couple of the things that you do differently in your practice?
Sure. I have two that I'll talk about. And the first is a little bit of a cop-out on the question, but because, you're right, I have this entirely computerized system, but that's really part of the biggest thing that I try to do differently, which is absolutely nothing in my practice or the way I practice is sacred. So the way lawyers say things, do things, write things, what they write them on, like I will savagely put anything under the microscope and see if I can computerize it, get rid of it, or find a better way to do it, or find someone else to help me do it in a better way. So that's kind of my core underlying philosophy is we have to look at, we can't have any more sacred processes or little rules or traditions anymore. It's kind of a change attitude thing. The second thing, and the more of an actual answer to your question, but I don't use, and I don't plan to ever use traditional reception. So I use Microsoft's VoIP phone. So any electronic device I have people ring my number, it rings to their, there's like an electronic receptionist and stuff. There's some options, but I don't, I think part of access to justice might be accessibility. So people really want to talk to their lawyer, not the partner technically in charge, not the student working on it, but the person who's actually calling the shots and making the decisions and has the knowledge. So I have no plans to, I'd have to talk for an hour to tell you exactly why, but I have no plans to scale up my business model and build a pyramid under me. And part of that is I want to be able to have my client list. As soon as I get to the point where I can't recite in my head the key facts of this piece of litigation, I don't know the client's name, I don't know the last time we spoke, I can't off the top of my head advise them, then I'm going to not take any new cases. And that is, just because I can do it because of technology. I like the trusted advisor role of being a lawyer. That's one of my favorite things, is taking on making decisions is hard, especially when there's risk involved. And for some people, it's easier than others. And I have a bit of a steel constitution to say, I think you should do this and not that. And I like that part of it. And that's, I think, where people really get the most value out of lawyers. So that kind of accessibility piece is, I think, the thing that I do most differently, especially in business and commercial litigation, because although it's changing now, a lot of the people who are doing my type of work are at the big national firms or a few smaller boutiques, and they're still, for the most part, mostly in that sort of pyramidic partner, junior, receptionist, multiple assistants, multiple paralegals kind of role or structure.
Joel, I was wondering as I was listening to you, and also when we were talking and learning a little bit more about you earlier, you make a point of learning about technological tools, and you mentioned using them or finding somebody to help you use them. Why do you think that technology is an important piece in legal practice?
Well, how long do we have? My first question, just cut me off when I'm done, okay? But the most important thing is lawyers don't realize this because, look, we came out of, I came out of law school when we were already deeply into the internet age, okay? And even my experience as a young person and then a student, everything was computerized. And everyone in the rest of the world, outside the bubble of lawyers who have this privilege of not having to adapt to technology because we have a state-granted monopoly on our services, everyone else but us is using these services. So grannies are using FaceTime. Everyone's text messaging. Everyone is trading on e-trading apps. Everyone is using Teams and Slack, and we just don't see it because we are very busy. We get to our offices. They don't have that level of technology for a whole bunch of reasons. And we just don't draw the connection that, or we don't always become aware because clients are reluctant to give lawyers really direct feedback. We're not always aware how far behind we are, even regular consumers, even people who might be self-reps or, might be in a, very low income. They often still have a phone or have a their life is mediated through the internet like most regular people is still. So there's, I just think it's about catching up to where the rest of the world is, especially other businesses. Like I think it's, embarrassing to be working for a tech company or a company with tech products and trying to, fax them things or not using Teams or, not using e-signatures and, at the same time saying, well, that stuff isn't safe or that's not good enough for you, but they use it in their own business. So why aren't we there? Right. So I'll just wrap it up there.
Good point. Thanks for articulating that. I think you hit the nail on the head. Laurel, over to you. Tell us a little bit about what you do differently in your approach to practice.
Well, as we talked about, Carrie, I think like almost everything I do differently, but a lot of what Sonali, Nicole, Joel are doing, I have elements of all of those things that they've mentioned. And it started with me not really wanting to fight with my clients about the bill, working with them so closely and then feeling awful when I delivered this huge bill. So I started with developing new services that were all flat rate. I have all my rates on my website. I mean, there's some that I have to say, I'll give you a quote in advance, but that's, I think for clients that kind of blows their mind initially is like, there's no hidden fees. They know in advance what they're paying. And I always take money in trust in advance for the fee for the service. So, I mean, I have 100% on my collectibles. But essentially, I think over the 4.5 years that I've been practicing this or developing my new services, is that I've changed my approach to how I think the philosophy about how I approach delivering services is a lot different than when I started and a lot different than where I thought I would be going. And so when people come in with their legal issue, so I just do family law. So everyone has, a separation or divorce. A lot of people will come in to see a lawyer at that point because they know something must be done. They're not sure what. And rather than, just trying to fix the legal issue and we kind of look at a wholesome picture of their life. We get really into the dynamics between them and their spouse and in their family and talk about a lot of things that might not seem related. And then ultimately I start with teaching them about how to, find issues where maybe they've had some problems with conflict resolution or setting boundaries and being assertive and like how to do that in an assertive way and respectful way without being aggressive and awful and essentially escalating illegal issues so that it gets to the court. I mean, obviously there's always legal issues. I will offer services such as legal drafting and preparation for court, et cetera. And that's a part of the services, but essentially it's that coaching, that one-on-one working with someone to help shift either their behavior or their perspective or their thinking on a certain problem so that they're able to resolve the issue themselves. So I'd say that's a major difference about how I approach things.
What feedback do you get that inspires you to keep that model going?
I get a lot of positive feedback. I think the main thing is that people feel empowered at the end of it. They feel like they've learned a lot. They feel much stronger. They feel much more confident and assertive, and they say as much. And then the other thing is the ease of our service. Using our services is a major point that they're just so pleased with. I mean, I've practiced for about 6 years in the traditional way, and now 4 years or 5 years now in this new way. And I'd say in the last 3 years, I've received more positive feedback from my clients than I have throughout my entire career. So they're happy and they feel better at the end.
Thanks, Laurel. We're going to come back to you in a few minutes here. Just for the benefit of some of the people in our audience, and I know others are very well familiar with this, there's something called the Access to Justice Triple Aim. And that refers to 3 key pieces. One is to increase the number of people we reach in order to help them with their legal problems. The second is to improve the experience of the users of our system, or when you think about lawyers and law firms, our clients. And the third is to improve the cost, whether that's the cost of the system as a whole or the cost experienced by the users. So you can hear from the comments we've listened to from our panelists that there's elements of that. It is, what can I do to make this better for my client? How will this help them? How can I reach more people? Because it's like Rebecca was saying, you're going to where they are and you're giving them the targeted thing that they actually need. So it's interesting as all of you are speaking that I can hear echoes of that's what the triple aim for access to justice actually looks like in practice. So thanks for sharing those pieces. Chilwyn, we're now going to come to you. And again, like all our panelists, you do many things differently. Can you share a couple of things with us?
Sure. I need, the buzzword of 2020. Can you hear me okay, Carrie? So let me, I need to put my comments in context. I'm not able to do unbundling or fixed pricing on a website. My target market are the clients of Blake's, the Carthy's, all the big firms, Hunter Litigation, McEwen. I am trying to gain market share in that area. So that tends to be fairly high in litigation and regulatory defense. Unbundling is difficult to manage. So is fixed pricing in terms of something like a retail model. But my experience is informed by, as you mentioned in my intro, I did take a couple of years out from law. I was not satisfied with the traditional way of doing practice. I started with a tech service called Fired Without Cause. It was a wrongful dismissal service for $39.99. You could enter in the Bartle factors, and we had this huge database that we collected of wrongful dismissal awards and the reports that it spit out. We would get feedback from clients saying, "Oh my God, this is the best $40 I ever spent." We always said, if you can increase your severance by 1 week for the average Canadian, it was 1 month of rent or 5 weeks of groceries based on the kind of CPI indexes that Canada would produce. It wasn't a scalable business because we couldn't go to the United States, we couldn't go to the UK. It really exploited the fact that Canada's wrongful dismissal system hasn't changed since 1976. With Bartle, that test is pretty stable. And also what was starting to happen is I was getting a lot of requests for additional legal service, more traditional legal service, but in wrongful dismissal. And it's just not my game. After my MBA, I wanted to create a business model. I didn't want to practice employment law. And so I tried to shop around and sell the system, but at the time, no employment lawyer was interested in buying my system. So like any other good business person, I packed up, took my licks, learned my business lessons, and I moved on. I think it might have been just a little early in the marketplace, similar echoing to what Nicole said, to run something like that. And that was back in 2008 is when I 2008 to 2012 is sort of when I tried to make that a go. We had another service called Contract Tailor, which was sort of an unbundled kind of commoditized way of producing drafting and legal management. We pivoted from retail to institutional in-house to law firm markets, and from on-premise delivery to SaaS delivery. And anyways, a whole bunch of business lessons learned, and it didn't take off, and that's okay. I decided that I want to take those lessons and start this firm. So to answer, I just need to put that in context because it's hard to describe, because I'm going to give you something general with some specifics. I think what we do here at Ascendian is, one of the things we do differently is we focus on price, like right up front. So when a client comes to us, whether it's an insurer, a big corporate client, public company, an owner-operated company, they come to us with a litigation problem. And what we do is we don't go, okay, well, in order to solve your legal problem to get to trial or get to a mediation result, we got to do all of this discovery and examinations and all those things. What we say is, well, what can you afford? Like, what's your target budget for this engagement? And they always undersell. Like they usually can afford about 3 or 4 times more than what they've told you, but that's okay. But we start with that price and we say, okay, well, for $50,000, this is what you can afford. Now, I'm putting that number out as just kind of a blanket number. I know that's beyond kind of the traditional access to justice model, but I'm just trying to share the thinking. What we say is, okay, well, for $50,000, you're not going to trial. Like, there is no way you're running a 20-day trial on $50,000. But what you can do is this, and this. We have one client that is facing a 20-day hearing in front of a regulatory body. This person can only afford $10,000. It's a very serious allegation. This person faces significant public prejudice. But what we've negotiated is that we are going to simply provide some legal coaching for this person in the background, how to conduct examinations. We're going to do some video practices of coaching them how to do an examination, and we've undertaken to do their final argument. But we're not going to sit in for 20 days. We're going to rely on transcripts of the evidence. We're going to rely on knowledge of the law and put together a written argument that will at least help them through. And that they can afford that. But in terms of the value add that a lawyer can provide, I think that's where we can add the most value, instead of sitting around in a hearing room watching 20 days of evidence, most of which I'm going to forget because I'm going to rely on the transcripts anyways. So I think we need to, but that only comes around when I say, okay, what can I do for $10,000? What it does, though, is it drives a whole bunch of other behaviors. So, for example, we make it a practice here at Ascendian that we don't do opinion letters. Like, so much time is writing these opinion letters that most clients, frankly, don't read. They don't care. They want to see the last line. And even in-house counsel, they say, we don't want to see these big, we're going to assume you've done the legal research, give us the one paragraph. And yet hours are spent writing those and proofreading those. And it's of very little value to the client. But of course, I know what the regulators will say as well. How can you tell? Like, what if you didn't cover everything? Well, we do PowerPoint presentations. So we find that we do like the classic 5-slide PowerPoint presentation. The usually business clients are used to seeing them. They can absorb that information. It's visual. And in order to meet our compliance demands, we videotape our presentations, we audio tape, we produce a transcript with Otter AI, and we send them the transcript so that it's very clear on the record everything we told the client, so that if a compliance issue arose, we can provide full disclosure of what we said to the client. We don't have to document them in a long opinion letter. We also do a lot of videos. So when we get ready for examination for discovery, we don't take an hour to sit down and explain what examination discovery is. We produce a number of videos, some how-tos and tutorials to help our clients understand what their obligations are. And that, again, that saves so much time and enhances the quality of legal service delivery. I'll tell you, our clients love it. Like, even not just retail clients and owner operators, but in-house counsel we've had very positive feedback because quite often, like, for example, let's say with the videos, many in-house clients see us helping them educate their in-house clients how to do better, and takes the load off of the in-house lawyer from doing that work for them. So, and the retail clients, of course, enjoy it because they get like the hour online with us. So they can sit on the couch and watch a video on their phone and learn how to do an examination for discovery. And so that the hour that we meet with them, we're not wasting with the basics. We're really drilling down on the types of questions that they're going to be asked and practicing what an examination is like. Huge value add for the client. And so I guess the last thing I will say that is engendered by price, and I think leads to more the mission of the why I'm doing what I'm doing, is that I spend a lot of time on the production function of a law firm. Very mindful of using the Toyota production system, operations management theory, lots of time and motion studies on my staff and our team to be very clear about what are the steps, what's the time, what's the resources required to produce a legal product. We're constantly measuring against standards and looking to reduce our effort and reduce our time, not expand it, because we don't want to charge the clients more. We're the only industry where we're always raising prices, and every other industry is trying to cut prices. It's amazing. So it really, like I would say it changes the role of the senior lawyer. So my utilization rate is not 60, 70, 80%. My utilization rate is probably about 20%. I spend maybe 2 or 3 hours working on actual client, like technical work. The rest of it, I'm coaching, I'm meeting, I'm convening, I'm organizing, I'm looking at project management, I'm watching the system, and I'm convening the culture to make sure that we're delivering the best legal product. And so that's one of the things that we're doing differently. I do want to do a quick shout out though, because there's some other people in the room that I think really do need to be acknowledged. I do want to recognize Linda Russell, Raymond Lee, and Rob Cito at CLABC, who are also presentation partners here. They're real pioneers in legal knowledge management and democratizing for kind of the average lawyer legal knowledge, which is critical to access, absolutely critical to access to justice. Kate Gower is a huge pioneer in legal technology, especially on the online trials. Follow her on LinkedIn. Case Lines is an amazing product, for example. John Rogers and Jane Morley are also online. They are huge leaders in the ADR space. And so I think they need a shout out because ADR is, again, a huge part of the access to justice model. So sorry for, it sounds like an Academy Award, but it's really important that we recognize in this community that lots of people are rowing the boat against this stream. And it takes all of us, a community, to row the boat to provide justice for all. Thanks.
Thanks, Dylan. I think you took all the questions we were going to talk about and rolled it up into one. That's completely fine. There are a lot of interesting points there, particularly when you talk about looking at the system of the office. That's really different than where we started off in law school. The system of the office and how the different functions need to work together to serve the clients, serve the users of the system. And that's definitely a part there. I'm going to invite Rebecca to go on screen. And we have a few questions in that have come forward from our audience that we'll answer live. And then I also have a couple of questions. My sort of last question for all of you: what do you wish was different about the regulatory piece, the law school education piece, or the court administration piece? That's a big question. I'm just parking that in your head, knowing that we're going to get to that in a few minutes. But let's just have this conversation and cover off some of these pieces. And, for our panelists, if you can just indicate by, just raising your hand there if you're prepared to give it a go to answer the question. So we have a question to find out your views, and we're going to actually, Rebecca, if you're prepared to start with a response, that would be great. But what are the access to justice prospects for AI and machine learning? Like, how do you take that concept and marry it up with access to justice? Do you have any initial thoughts on that? And maybe, Rebecca, if you don't mind starting, and then if there's another panelist who wants to weigh in, that would be great.
I think that's a great question, because that technology is changing so fast and there's so much promise there. I'm really bad at predicting the future, so I'm going to tell you what's happening now, which is in the consumer space and sort of the consumer facing space, almost nothing, right? So there's some really sophisticated ways of automating processes and document creation that make it much easier for ordinary people to write a complaint letter. You turbo taxify something. And there are some wonderful advocacy tools that use available data to do things like identify who's in financial peril by seeing whose water bill has been posted as past due in the city of Philadelphia, or who are the absolute worst landlords in New York City, right? So you can apply data analysis tools to that kind of stuff. But real AI is learning by consuming information over time. And so you have some people who are pioneers in my world here in the US, like Margaret Hagan, who's trying to teach an AI bot how to read a Reddit stream and see how ordinary people talk about justice problems. But that's a slow process, right? So can you issue spot in ordinary language using a computer? Is what you're after there. And I think there's a lot of promise there, but it's very challenging. And so we watch technology move at the speed of light, and it might take her 5 years, which seems like a long time in this world. So I think we'll get there eventually, but we're definitely not there right now. For true AI.
You're on mute,
Go
Carrie.
ahead.
Sorry, I promise I'll keep this to a minute. I'll use this as an opportunity to talk about what needs to change in law schools. We need to add quantitative analysis for lawyers, period, and logic and coding knowledge because that's the future. At our practice, we are using quantitative and statistical methods far more, not only internally, but as you know, Carrie, from the presentations I do for CVA, a lot of around stochastic and forecasting models using Monte Carlo simulations for litigation forecasting. We're creating a lot of data models for costing for clients. A lot more of these AI tools are being used in the tax area, case research area, in the document discovery, right? The experiential tagging models that are being used by programs like Relativity, which are the high-end e-discovery programs. They're becoming more and more common, but we're delegating the judgment to mathematicians then, and lawyers are starting to take a back seat to these algorithms, and lawyers need to learn quantitative methods so that we can understand the assumptions underlying these models and help understand them and tweak them, and most importantly, qualify them for the clients when we're relying on them to provide client advice. There, that's a minute.
Thanks. Shifting focus a little bit, one of the questions is, why do those of you who do post your fees on your website, why do you think that more lawyers don't do that? And do you think the fact that you do helps you attract more clients?
So I do have flat fees on my website. I think, again, it depends who your client is. I mean, if your client is Microsoft, I don't think you have to be worried about that so much. But I think, the vast majority of people are terrified of lawyers and fees, and so I think it's an important communication tool. And the other thing is, if clients don't have a budget, then it's efficient for the prospective client and efficient for you that they know what it is. So I find I do, and this is part of unbundling, but I find clients certainly prefer flat fee if that's possible. So if it's basic planning, if it's unbundling incremental steps of litigation procedure, like it really gets their anxiety much lower. And the other thing is, it's in terms of explaining what the constituent parts of an advocacy process are and what each of the pieces will cost, is the client feels like they're more of a participant. And the days when there's the democratization of information, which is wonderful for everybody, but we are not, sadly, we don't have the respect and the prestige that we may have had a generation ago. And, if we're going to stay relevant, and, if the robots aren't going to take over, and I just want to say, like, listening to Chillin, I think probably a number of players are probably terrified that we're all going to have to turn into coders. I mean, at the end of the day, the robots are not going to be able to take away wise advocacy. No robot is going to be able to do that and be truly present for a client, like just like what Joel mentioned. And so I think it's focusing on what we. But can I just jump to what I think the Law Society can do?
Can we just pause that one and we'll come back to that question at the end? I just was sort of setting you up for, we'll do that in a few minutes. Right now, we're going to deal with some of the questions of our audience. Thanks, Nicole. Sonali, did you want to make a comment about the posting of fees and what you see happening there?
Yeah, I mean, like, just sort of riffing off of Nicole, I think, I think that from my perspective, and I posted this to the person who asked the question as well, too, was that I think because we are a self-regulated profession and there's no regulation of fees within the province of British Columbia, like there isn't any kind of incentive to post fees on your website. And also because when you look at sort of the traditional sort of what Joel was describing as the like traditional firm with the tier structure, I think fees run on a spectrum based on level of experience, year of call, all those kinds of things, whether you're a partner, junior, et cetera, et cetera. But I also think going to the point of like lawyers being sort of seen like dinosaurs in the world of technology, a lot of people just haven't updated their websites or aren't like thinking about this. And because most referrals come from personal recommendations and based on the reputation of a lawyer, there hasn't been this need, I think, prior to the pandemic. And I think what the pandemic has actually done has like forced people to like have these discussions and think about it like, hey, should I be posting my fees? So I think from my like hopeful perspective in terms of fee transparency, I think we're going to see a lot more websites with fees on them. And from a personal point of view, I think the second part of the question was whether or not posting the fees help to attract new clients. I think it does. I think it does. And from a lawyer's perspective, like oftentimes, when you're doing sole practice, you get sort of in the beginning of your practice, sometimes you get bombarded with lots of free consults. And so you can sort of mitigate that by like posting like, listen, the consultation fee is X, I've got an automated system. And that way, you're not having that awkward conversation. And then you sort of move forward from that. And with unbundling, you have to have like true informed consent, and setting up a budget and a fee schedule helps to really minimize the scope of engagement when you're dealing with limited retainer. So, yeah.
Thanks. Joel, I think you wanted to answer that, get in on that AI question a little bit earlier. Was that correct?
Yeah, and I have something on fees too, if that won't take too long.
Go right ahead.
Try to keep it short. So as a hobby, I follow a lot of software development and coding and AI stuff, and I know a decent amount about it from a technical perspective for a lawyer. And so, I really I've looked at a lot of platforms. I've looked at a lot of technologies that are being sold in, I don't really say AI because that's just kind of like saying computers. Machine learning is where the bulk of the AI stuff is coming from for law right now. In litigation, there's not very many great opportunities to use it yet and really see a benefit. In areas like transactions and a lot of retail services and stuff like that, there are huge opportunities. And I think machine learning apps and websites and stuff could replace a huge segment of legal services really, really quickly. And especially if it wasn't for the anti-competitive regulatory environment that we're in here. So But in litigation, it's a lot harder. And there's often this argument about litigation's too bespoke. You need this kind of human wisdom and intuition and stuff like that. And that's often used as an argument against using machine learning tools. And I don't really like that argument. I'm not going to sort of perpetrate it. I think a time will come where we'll be very surprised by how good these tools get, even for us in litigation. It's just really early. And also, we do use some stuff that we don't really know about. Like my Outlook gives me meeting insights when I have an email coming up. That's machine learning. It's recognizing some text and saying, oh, this is probably what you're doing. So it's being built into stuff we already use, and very quickly and all over the place. The best area right now for machine learning is in e-discovery software. So I use this Relativity. I've been using Nuix lately. It used to be Ringtail. Has just mind-blowing capability to show you potential relationships between documents. And so the reason I think that machine learning has potential to really change things in access to justice is, so we often look at the hourly fee. What's the rate? And this will segue into the price question. That's not the most important thing, because if your case is going to take 1,000 hours, it doesn't matter if it's $100, $50, or $800 an hour, because most people aren't going to be able to afford that unless they're a business and they really want to. And 1,000 hours is a very short. That would be like a fairly simple trial in some context, right? So it's time, not price per hour. And especially as we start to think about pricing more in terms of flat fees and segmented for services and stuff, we're going to start to change the way we think about price, less and less about what's the label you stick on the hour. So I think there's, in terms of, we should be adopting tools that let us save time. That's the most important thing. I echo what Chilwyn said about all that stuff, because that's the best way to deal with price. Now, shifting to posting rates, one of the main reasons I started my practice, I wanted the freedom to offer any kind of billing arrangement that might suit me and someone else, right? As the owner, I know my overhead, I know what I can offer people or not. And so I've done maybe 4 or 5 alternative billing arrangements. I've offered it to anyone who comes in the door. It's hard to figure out how to do it. It's hard to sell clients on it who have an unrealistic optimism about legal services. Well, I'll just get them to do a letter. It'll take 3 or 4 hours, $300 or $500 an hour, and that'll wrap it up. No, that's not going to happen. So there's this optimism about where the case will go and hourly is kind of looked at as a pay-as-you-go model. And that's just not really true, especially in some contexts it might be, but not in litigation that probably has legs. I tell everyone I get demand letters from other people, from my clients, and I don't care about it. It's just lawyer barking, and it really doesn't move the dial at all on anything. So I don't write them in the first place. And I tell people, look, if what you want is a demand letter and you think that's going to solve your legal dispute, I can refer you to someone else, because that's not really, I think, how it'll go, and that's not really what I'm in this for. So I couldn't put pricing on my website because it's variable. I tell everyone, I basically ask, are you okay? Because some of my clients are medium-sized companies, some are small companies, some are wealthy individuals, some are normal middle-class individuals. And I have that conversation, like Chilwyn was saying, what can you afford? I don't really unbundle things. I like to try to be the hub of the litigation and do most of the file. That's just my own interest. But I do offer a completely variable rate. So, if you are a company with a lot of revenue, I'm going to give you a higher hourly rate or a higher flat fee. And a lot of people don't like that because it shows the arbitrariness that is in hourly legal fees, but it is arbitrary. So I don't mind telling people that this is negotiable. I think I covered both things there.
No, that's perfect. Thanks. One of the things, Rebecca, that you were talking to us about is the strategy of going to where the people are. The example of, a lot of people with health concerns may also have an underlying or a related legal problem. And so there's a connection there. Or the other piece was, you're in a bar and you can sit there and look at some little legal information about a personal relationship. Interesting facts. One of the questions that has come up is, and I'm just sort of wondering, how do we know where to go? So we have something in British Columbia, family justice centers, and the idea is that they're in places where people will go, and what we find sometimes is you think, okay, it's related to the courthouse. So it's embedded in a courthouse. They're going to be going there anyways. That seems to be a good place. But then there are some people who are like, I don't want to go there. Maybe they're not yet in court, but they don't want to go there. So what are some things that we need to keep in mind when we assess the where the people are piece?
Well, I think, this is something that's very dependent on geography. So if you're in a big rural part of my country or a big rural part of your country, where the people are is a very different question to consider than if you're in New York City or Toronto and people are walking around and things are quite dense, and you can imagine neighborhoods that have some character and some sense of themselves, and they have boundaries, and so you want to make sure there's something in each one of them, right? So it's not just something in every postcode, but something in every community. So I think that's something to think about. What is the physical possibility of reaching people given the kind of place that they live in? I think the other thing to think about is if people don't connect their problems with law or justice, why are we naming everything justice and law? Like, why are we naming this the I can help you deal with this problem you have with your neighbor center? Or, why are we not labeling, branding things around the experiences as people have them, rather than the institutions that we set up 200 years ago based around professional ideas? And I love how Joel keeps talking about professional monopolies, because that's another part of this also. Just to give another example, if you look at what really wealthy organizations and people can buy, they can buy multifaceted, multidisciplinary advice about the situations that they confront. That isn't just, how do I respond to this problem that's happened to me? It's, can I do this thing? No. So as a legal aid lawyer friend of mine likes to say, rich people pay lawyers to tell them no all the time. So how can we embed access to expertise and knowledge so that everybody has the opportunity to do this kind of preventative contact with somebody who can give them good advice? And that good advice might be, don't do that.
One of the questions that has been asked, and maybe Laurel, you can take a stab at this one, and that is, how do we move forward with some of these A to J improvements that are technology based without leaving behind those who don't have real access to computers or privacy to deal with one, or in some cases we know there's also internet issues, but how do we advance but without leaving those people behind and creating or perpetuating an A to J problem?
Oh, that's a difficult that's a difficult question. I think it's that one is sort of essentially what Chilwyn says, is you're focusing on yourself providing more efficient services, and therefore you're able to deliver services at a lower rate potentially to the client. So it's not about them having access to computers and phone. I have a lot of clients where that is, maybe the only thing they have access to is their cell phone, or they might not have regular cell service. And so, these clients are also deserving of good legal service, even if they would tend to be on the lower end of the spectrum, hopefully legal aid clients at that point, but still they deserve good legal service. And so if you're going to be providing that, I think you have to make your own overhead lower, essentially, and your services more efficient. So you're providing your services to a greater number of clients, but spending less time in the admin world. So online, I mean, if they have access to a cell phone, online intake forms kind of thing, that they can access from their cell phone. Sometimes I think you're just going to have to pick up the phone or meet them in person and do things the old-fashioned way. And that is cumbersome time-wise, but I'm sure, with some creativity, you can always find ways to access or reach out to those people who won't have access to the computers that most of us will.
Because there's, like, you're highlighting the fact that there's two components. They're using all the technological tools that might be available to us as lawyers running a business that you use to improve your systems so your price point is lower. Then there's the use of technology to interact with clients, and those clients may not have that. And so therefore you need to say, okay, well, I've got a lower price point, and I can maybe take some clients who are in that circumstance and work with them in the different way. Chilman, you had some thoughts?
Yeah, I think some of the most efficient players in our marketplace is Legal Services Society and a lot of legal clinics, because they're forced to be able to serve people who have those barriers at the lowest cost possible. And we've innovated in those areas. For example, allowing non-lawyers to read a script to provide some basic legal information. And I appreciate there's a regulatory piece around, well, when does that cross into advice? But within certain guidelines and boundaries, standard scripts, standard videos, standard meetings, diagrammatic aids surely can help provide, at least make them net benefit to those individuals than where they were before. There's no reason why they have to be nonprofit, like tools that are exclusive to nonprofit entities. Like profitable enterprises, i.e. most private practice lawyers, can adopt those solutions. They're not restricted to legal clinics. And to the extent to which lawyers want to avoid looking like the McDonald's of law, but there's a reason why McDonald's is everywhere. There's a reason why McDonald's can offer 99-cent Big Macs, is because of standardization, scale of scope, scale of, right, all those concepts. There's ways that private practice lawyers can adopt those in order to reach a larger audience.
Yeah, fair. Well, let's now shift a little bit to that question of, and you can each pick one thing. I'm going to come to a round table, okay? You can each pick one thing that either you hope our regulator or our law society might change, which would enable something that would be easier for you, or you wish a court administration system would get solved at a sooner rather than later, so that embraces some benefit to your clients, or you wish you learned in law school because it's so critical to what you do today. So I'm going to start with everybody, then I'll come to Rebecca, and then we'll go to our Chief Justice for some final thoughts. So which of you would like to go first? Sonali, go ahead.
So very quickly, my hope is that it's around court administration, increased sort of like court services online. It's just backlogged and it's really difficult as a family lawyer. So my hope is that there's more people working behind the scenes to get those files processed that are submitted online through e-file.
We have an e-filing system, but it's bogged down, so we've got to do something to make it better. Got it. Thanks. Who's up next? Laurel, go ahead.
Just because it's sort of related to what Sonali's saying, I thought the change to allow self-represented litigants to file online was so major, and it should have been done years ago. But that aside, also the struggle I have is because I'm often coaching people to go and deal with their own litigation. I would love to be able to tell a client what's going to happen to them at the registry when they go to file documents. However, as a self-rep, they get treated much differently than lawyers do and are often second-guessed about what they're filing. And so I often get these panicked phone calls from the registry. I never really know. It's kind of a roll of the dice, and I prepare them for that. And I know lawyers have a little bit of that themselves when they show up or, file online. We're used to troubleshooting it, but and I don't know how it could be done, but it would be nice if the registry wasn't the biggest barrier to access the courts that my clients faced.
Right. Nicole.
So I have two wishes. The first one is just building on what Joel and Chilwyn said. So, as private practice lawyers, we have some clients that are, well-heeled, and we have lots of clients that are more middle income people. And, and again, the hourly rate can be somewhat arbitrary. So what you're going to charge somebody who has a lot of resources is going to be less than someone with less. Whether that's fair or not is it's a market thing. But we should use as lawyers to our individual responsibility for the access to justice, and that our well-heeled clients can subsidize us offering services to middle and lower income clients. So for us, I volunteered with Access Pro Bono, and Jamie McLaren is a huge leader. But we've got a sister business called North Shore Pro Bono. So if you call our line, it says you've called Heritage Law and North Shore Pro Bono, and you can get free of charge estate planning and free of charge family mediation. You just have to meet an asset threshold. And we allocate 3 hours every Friday to those clients, and they get exactly the same service, exactly the same resources, the same as every other client. And it's a way that you can integrate it into your practice and serve people. And we barely notice the opportunity cost, if that makes sense. And we're able to serve this totally unmet population. So that's wish number one, is that if we can all think about a way to integrate that more seamlessly into our practices. And then number two is my pet peeve is I want to get the Law Society to rescind Rule 3-58.1. It's a thorn in our side. So, the Law Society has decided that lawyers who are mediators, arbitrators, and parenting coordinators are not practicing law, and legal services are incidental to that. And accordingly, we're not allowed to put retainers into our trust account. We have to set up completely separate general accounts to stick those retainers in. And it is adding complexity, error, expense, administrative delay. It is the opposite of access to justice. And I think it needs to go. So that's it.
Thanks, Nicole. Joel, do you have anything on your wish list?
I have lots, but I think I'm going to go for the biggest and potentially controversial of all of them. And I think we need to take a really long, hard, honest look about whether full self-regulation is in the best interest of the public. Our rules and our legal tradition come from England. They had this conversation. They took a look at it. There's lots of jurisdictions that are introducing other elements into this. And I think you can look at our lag behind, in the courts and in the practice and in the ways that we're not serving the public properly. And I think you have to be a little bit deluded about human nature to think that doesn't have something to do with the fact that we control all the levers of power that handle how we get paid, how we serve clients. I don't want to be too apocalyptic about it, but the main reason I think this is that it now is the time. Lawyers and former lawyers don't have the skill set to deal with all of the technology and the changes we need to make to deal with sort of new technology, new things in society. I think we need to take a really deep reset on the practice, and I don't think we're ever going to do that if we just keep the same regulatory system here. I know the importance of independence of the bar, independence of the judiciary, and all of that stuff, but we don't have data on whether that's worth it. We don't take a realistic look about whether that's serving the public best or serving lawyers best. So, I know that's controversial in some circles, but a lot of lawyers talk about it. And we wouldn't be the first to take a look at it and just take a really hard, long think about whether we can change the fundamental structure that sort of drives the whole system.
Thanks, Joel. There's no shame in raising controversy, because what you're saying is lawyers are talking about it, and they're talking about it in a way that maybe other people aren't. And so no harm in having a conversation. for sure.
And
Chilwyn, over to you. Your one thing. I know there's lots, but your one thing.
Shout out to Joel. Everyone should follow Joel on LinkedIn right now. Awesome content every second day on some aspect of legal technology, legal practice, or corporate or governance. So I want to do a shout out to him, agree with him. But I'm going to put another, I think, equally controversial proposition. We need to have an honest conversation about proportionality of legal services and competency of legal advice. The number of times I've sat in chambers and I've got a complex matter, I'm waiting for those 5-10 minute matters, and there's a self rep there, and they're clearly lost. And I know that I can help them, but there's a fear in me that if I step up and say, my lord, or your honor, or my lady, can I just take this person out for 5 minutes and let's see what I can do and come back to you? I know that I could help that person and I could help the system, but all of a sudden there's this fear in me. Okay, well, I'm not a lawyer. I'm not retained. I've only spoken to them for 5 minutes. And, you know, LIF is going to come on me like a ton of bricks, and the law side is going to come on like a ton of bricks because I've tried to help someone in a unique circumstance for 5 minutes. And it's the same problem that people in clinics, LSS, so many areas where we could make I would say, not a perfect maximum benefit to the client, right? Lawyers like to think in terms of maximum benefit to the client, maximum advice, complete minimum risk minimization. But how about optimal in the circumstances? How about net benefit? In that moment in chambers, can I net benefit that client? But that's not how the profession talks about professional negligence and professional standard. Professional standards are defined in terms of the best. And I appreciate the naysayers will say, well, no, we do incorporate circumstances, but let's be real. That's not how most of us perceive it. I'm willing to put some money on that bet. So we need to change that conversation. And that involves the Law Society, involves CBA, involves a cultural change about what's expected of lawyers in the standard of advice that we give in the circumstances.
Thank you. So, Rebecca, your observations, I know you would have all kinds of lists there. And this is we could easily do this for a whole day, 2-day session. But what do you think are one or two things that would be really good for one of those three institutions to do differently?
So I'm going to pick one, and I want us to remember that your country and my country are democracies, and that means that law is a good for the people. It's not the province of the courts. It's not the property of attorneys. It is everybody's. And so I would like to see the delivery of legal services regulated in some way that focuses on the important stuff. And the important stuff is the ability of ordinary people to use their own laws. So that's access to justice. And the other important stuff is consumer protection, because that's an expertise that maybe a consumer can't necessarily make decisions about on his or her own. And so there may need to be somebody in there who's making sure that consumers are only buying things that are good and safe. But to go back to both Chilwyn and Joel's points, there are ways to do that very differently, but very effectively. And they're very different from what we do now. And they will look very different. There are jurisdictions in my country that are moving in that direction, and British Columbia is moving in that direction. So I think things are looking up.
Thank you. So for all of you who are attending today, I hope you witnessed the excitement around people doing things differently, thinking in different ways, suggesting things that are different, taking a stand and giving an opinion about things, even if it might be unpopular. That's the kind of conversations that are happening within the legal profession. Lawyers are changing their practices, what they do, and they're incorporating things in a different and new way. So for the law students who are listening, things are different, not widespread, but things are different, and you can look to do things in a way that makes sense from your perspective. So I want to encourage the law students with respect to that. And for the lawyers out there listening, I hope you sort of thought, okay, I'm doing some of these things too, or I'm doing other things that are improving access to justice, and I'm going to keep doing them. That's the whole point. And if you came here and you were curious and you wondered and you heard something that maybe you're going to give it a try, please do reach out to any of our panelists, reach out to the people that they were recommending and highlighting and shouting out to during the session. You've heard that CBA and CLE are having professional development moments on all kinds of different things in what some might say are still emerging, but we're doing it. So there's lots of places to learn and have the conversations and challenge those established norms. I want to thank all of our panelists for taking the time to be here, to prepare, to share. I want to thank Rebecca for bringing her wisdom to all of us. It's always good to hear that perspective of another jurisdiction, but of somebody who takes the time to look at these things and then also teach the rest of us. So thank you. And I would now like to invite the Chief Justice of British Columbia, Robert Bowman, to share his reflections on today being a key part of the Access to Justice Week and an event for the profession. And for our panelists, you're welcome to take yourself off video.
Thank you very much, Carrie. Thanks for this opportunity. I want to thank everyone who's participated in the background asking questions, but in particular, I want to thank the panelists for your provocative remarks. And it's clear to me that I learned so much by listening to you. It's clear to me that the profession in British Columbia, at least, is in good hands. I want to thank Professor Sandifer. Professor, we're honored that you were able to join us, and I'm impressed, and I'm sure all were impressed by the contributions you're making not only at home, but also abroad. Most of us try to improve our little corners of the world, but it's inspiring to see someone working hard to share ideas that transcend borders. As members of the Canadian Bar, I hope you are all energized by the knowledge that you are also members of a larger community that's focused on improving access to justice. I deeply admire the innovative and thoughtful contributions of our bar, and we've heard many of them tonight. And it's good to know that Canadians are not alone in the fight for justice equality. It's good to know that we can stand on the shoulders of giants in this area located around the world. Justiciable issues are experienced by every one of us, as we've heard tonight. It's a universal truth. Barriers to justice in one form or another exist in all jurisdictions. But the silver lining is that we have an international community of critical thinkers and innovators like Professor Sandifer, who've made finding solutions their life's work. So I encourage you to think about that, lean on one another, and consider making some exchanges at this marketplace of ideas. In 2020, the BC Bar began by reading a groundbreaking report commissioned by the BC Human Rights Tribunal, authored by Ardith Wacham. And I note that in 2021, we began the year by welcoming Ardith as Justice Wacham to the bench of British Columbia. Ardith's report explained to the tribunal why Indigenous people are not turning to it with their experiences of discrimination. Justice Wacham's work and recommendations are relevant to all of us working in the justice sector. Removing barriers is not enough. We must expand our conception of access to justice in order to deconstruct this ecology of exclusion. The recently announced family justice leadership strategy by AIDA-BC also challenges our conception of access to justice. Rather than just removing barriers, the strategy centers one fundamental societal value: family well-being. With that North Star guiding decision-making along the way, the barriers are doomed to fall. Foundations are being laid for a Transform the Family Justice System collaborative led by AIDA-BC, which will serve as the bridge between innovators, like all of you, and those responsible for the operations of the family justice system. The themes that emerge from Professor Sandifer's research, the Family Justice Leadership Strategy, Justice Wacom's report, are all broadly applicable. A primary one is that access to justice doesn't mean access to the courts only, and we've heard that tonight in spades. It means the whole sector is intended to enable people to recognize, avoid, manage, and resolve legal problems and disputes. Quite simply, to live better lives. As Professor Sandifer writes in her article, Institutions of Remedy, quoting, "The fulcrum point in equalizing access to justice is institutional design. Greater access to lawyers will unquestionably be part of expanded and equalized access to justice. But by stepping back from law, and we heard this tonight, we can examine additional opportunities to expand and equalize access to substantive justice by selectively redesigning institutions of remedy," close quote. And I think that's been a theme of all the panelists giving us their life experiences tonight. As the professor's research and the BC experience make clear, the public must be given reasons to turn to our system, lest it become irrelevant. We do that by designing our institutions in a manner informed by empirical evidence. And the evidence suggests that we need to put people at the center and design our solutions around them. It's clear by the fundamental paradigm shifts proposed by members of the bar that you recognize that need and are ready to do the hard work. And I personally am energized by that thought. Thank you so much to all of you.
Thank you very much. And that concludes our event this evening. Take care, everyone.